Hi, my name's Judy Marrocco, and I am with Compass. I represent buyers and sellers, obtaining real estate here in the Bay Area and mostly in San Francisco. And because of all the questions that my buyers and sellers have once they buy real estate, I decided to invite Patricia Fonte, who I refer a lot of business to because she's so good. And I decided, hey, let's just talk about what happens when you own real estate. I think I outlined quite a few questions about things that come up about all around owning real estate. And Patricia, I could either ask you the questions or you could just start talking because I think
ask me the questions. Yeah.
Well,
and
okay,
I think David and Lucy should also feel free to just jump in and get your questions answered. How often is a lawyer just there? I do want to say that anything that I say today is not legal advice. The answer to any legal question is it depends. Depends on what? Depends on the application of all of your facts, just not the facts that you think are important right now, but all of your facts to the law. And that's why the courts are full of people fighting, because it all seems obvious to each side, but the law has to be parsed, right? And so can't give you any legal advice, but today we're going to just talk about general principles.
Okay. So with that in mind, a client of mine owns a house. So now what? They are two individuals living together. They consider themselves a couple as if they were a married couple.
I'm so sorry. I'm sorry.
What?
The doorbell. I'll be right back.
Okay. All right.
I'm going to pause.
Okay. So let's say I'm helping two people who consider themselves as if they're married, but legally in whatever state, and we'll use the state of California because that's where we are now, they're not legally married, and they buy real estate together, they buy a house together, and then an unfortunate thing happens and one of the two passes. What happens with the house? So
depends on how they own it. Now, a lot of people think, well, the bank owns my house. That's not how you own your house. The way that you own your house is stated on the front of your deed. Your deed says that you either own it as a tenancy in common, community property, joint tenancy. There might be a right of survivorship written on the front of your deed. And so the first thing you want to do is you want to look at the deed. And then you want to make sure that that deed actually makes sense and is the correct one that you're looking at. Because what can often happen is you're looking at your deed, but maybe it's not the one that you use to purchase the property. It might be that there have been refis in the intervening years. And so there might be mistakes in the deed. So you want to make sure you're looking at the deed from when you acquired the property and what does it say? So between unmarried couples, if there is that survivorship language, then it's likely that the unmarried partner will just automatically get that property. It's not all fun and games though, because that 50% ownership that you're inheriting is going to get reassessed. So you're going to get a big tax bomb is going to go off. And that, you know, we all know that that property tax gift is forever for as long as you own the property. If you own it as a tenancy in common, if there are no survivorship provisions on that deed, you're probably not going to inherit it. And so if your unmarried partner does not have an estate plan that says, when I die, my partner gets my portion of this house, my ownership interest in this house, you are not going to get it. It's going to go to that person's parents. If their parents are deceased, it's going to go to their children. If they don't have children, it's going to go to their brothers and sisters. It's not going to go to you. So this is a real danger zone for unmarried couples. It was just in the last year that on one of my mother's motherhood Facebook groups, a woman posted that she had two young children, and 4 and 5 years old, maybe younger, and her fiance died. They were going to get married, but they weren't yet. She was living in his house. And I guess his family didn't like her because now she doesn't have anywhere to live. There are always arguments to be made, right? You can always sue. You can always do something. But the short-term answer is you don't get it. You don't get it without a fight. And most of the time you're going to lose the fight. So it's really important if you own real estate with somebody that you are not married to, whether that is your romantic partner, a good friend, your, your siblings, your parents, whoever it is, that you are very, very clear on what is supposed to happen when one person dies. And, while we're here talking about unmarried people, let's talk about mom put me on title to her house because she thinks that means that when she dies, I get it. If you have siblings, that is not at all what it means. It means that you will get whatever, say you have there are 4 of you total. You'll get an additional 25% off mom's 50% interest, right? That's all you get. But the rest of the siblings also each get their share if mom doesn't have an estate plan. You've also opened up mom to a whole bunch of problems. And mom may have done this and not told you anything about it because someone told her that this was an estate planning tactic. It's not. This is a very bad idea to put the next generation on title because mom puts junior on title. Junior goes out and creates a ton of liability. Junior is underinsured. So the creditors start coming and looking at junior's assets. Oh, look, junior owns 50% of this house. Terrible position for mom. And it's also, it doesn't solve the inheritance problem for junior. So everything goes great. Junior's a wonderful person. Mom dies. Now junior owns a house with his other 3 siblings. That was never the intention. And that other 50%, we have to look at the Prop 19. Maybe the part junior's getting, if he's living in the house, doesn't get reassessed, but the rest of it, it's a mess. And I hope that you're not following this. I hope that none of this makes any sense because you can't do this by yourself. It's really incredibly complicated.
Yeah.
You probably don't understand what your deed means because it's all gobbledygook nonsense. It's really important when you buy real estate, make sure you understand how you own it. And then you have to think about what happens when I die? What do the statutes say where it goes? What are the tax implications of where that goes? And how do I get around those defaults?
So let's say you're a single person that owns a home and you have ideas of what you want with that home and you die and maybe you didn't put it down on paper anywhere. What happens to the house because you don't
there are statutes that tell us what happens to the house. We use the table of consanguinity and the laws of intestacy. So if you're single, no kids, it goes to your parents. If you have children, it'll go to them in equal shares. If you don't have parents or children, then it's to your siblings. If you're an only child, then we're still going up to the grandparents and then down to the aunts and uncles. So we're really going through your bloodlines, your family tree to figure out who's going to inherit from you.
And how long does that take? So let's say the person passes away and with no will or nothing written down. How long does that take to get all that straightened out?
Well, pre-COVID in the Bay Area, 2 years was typical. I don't know now because the courts are so backed up. It can take longer. And
what happens to the house while this is being sorted out?
Yeah, it's interesting what does happen to the house because is there money to pay the property taxes? Is there money for upkeep? Is anyone allowed to rent that house? What happens? Well, it's all up to the judge because the judge is looking at all of the assets and he's assigned an executor. Someone is in charge. There's usually a lawyer assigned to it. And so it depends. I don't know what's happening. And let me tell you a horror story. So if you own real estate with, let's say, a condo or a TIC building, these small buildings, maybe up to 6-10 units. This happened to friends of mine. They owned one condo in a 3-unit building on Dolores Street. The guy downstairs dies. No estate plan, nothing, sudden death. He does not have children. His parents have died. He's an only child. His aunts and uncles were dead. And so now it's myriad cousins on cousins on cousins on cousins. For 3 years, my friends were not able to get a decent rate on a refi. There were no capital contributions to paint this house or to put a new roof on it. The property taxes were not paid. And then they decided, we can't take this anymore. We want to sell it. They couldn't get a good price. They had to wait for 3 years for all of this to finally go away. So you're not just hurting your heirs, you are hurting everybody else who lives in that building with you.
That's
Everybody.
in- So if you're buying into a building, and I think this is probably even more true in a TIC versus a condominium.
I think it's exactly the same.
Is it, okay. What's a good way to approach buying in and protecting yourself?
Your realtor can pull the deeds for all the other owners in the building. And so you can look to see, do people have a revocable trust? Has that person's ownership interest in this TIC or their condo in this building been transferred to a revocable trust? And if not, you know that if you do purchase this, that one of the first conversations that you're going to have with the other owners is, look, this needs to get cleaned up. It used to be in TIC agreements that estate planning was a requirement, but I haven't been seeing that. Like for years, it was always just there. And so we could point to the TIC agreement and say, hey, look, everybody, you're in violation of your contract if you haven't gotten this done. I don't know why that provision has disappeared, because the last couple of years I'm not seeing it. And I'm not seeing it in like the condo HOAs, which is a problem. And so I am talking to my real estate attorney friends about this, because it's detrimental for everybody living in the building.
So let's say you do have or you want to put a trust together. Okay, so you want to talk about how you decide who should receive your real estate, who should be your executor, how you have to lay it out, who pays the taxes, what happens to the house.
Oh, this is an enormous question. Okay. So, it might help if I do a screen share and kind of talk through a little bit of the basics.
Sure.
And then we can dig into some of the more particulars. So right up here, do not buy real estate without an estate plan. This is really, really important. This is something that you should be thinking of when you are thinking, hey, I think I want to buy a house. And it's like in that thinking phase when you call Judy, hey, Judy, I think I want to buy a house. And she's like, amazing. You have to get an estate plan. You have to talk to a mortgage broker. You got to talk to your insurance agent, right? You got to assemble that team. An estate planning attorney is part of that preliminary team. This is not something that you do after. I mean, if you already own real estate and you haven't done it, yes, of course, let's do it.
Right.
If you do not have a revocable trust, if you have a will or you don't have anything, then I want you to look and see the fair market value of your property, because the probate court doesn't care if you only own 200,000 of that $1 million property. The probate court, if you die, is going to look at the then current fair market value. So let's say $1 million, pretty typical in the Bay Area. The lawyer is going to get paid at least $23,000. The executor, who will be appointed by the court, will get paid at least $23,000. And then there are $7,000 to $10,000 in costs. Here's who gets your stuff if you don't do anything. So you can find yourself. You have children but no spouse. Children get it. If they're minors, huge problems. And you can kind of find where you are. You have a spouse but no children. You have a spouse, one child, and a grandchild. Like, you can figure out who would get it if you did nothing. You can leave your real estate to whomever you like. When you're taking title, when you are buying something, for those of you who already have a trust, you're going to get this form from the title company that has all these different options for how to take title. I want you to take that, crumple it in a ball, and throw it away. You are going to call your realtor. You're going to call Judy. Say, Judy, I need to talk to a lawyer because I don't know how to take title. I don't know what it needs because it's complicated. There are huge differences on divorce and really big differences on taxation at death. And those two things are at odds. And so the best possible solution on death is the worst possible solution for a lot of people if they divorce. So it's complicated, and I don't want you to just make it up. So I always want you, when you're buying a piece of real estate, 2 deeds. And this is even if you already have a trust, 2 deeds. The first deed says, here's how I own it, either as a tenancy in common, community property, joint tenancy, separate property, even though I'm a married person. Is there a survivorship right? We lock that down, first deed. And then there's a second deed that transfers that property into the revocable trust. if you're married and you have one trust for the two of you, if you have this own separate property, mom left you $1 million and you bought a cabin in Tahoe with it, and that's yours, you can transfer that into your marital trust. You just have to make sure it's going where you want it to go when you die. But just putting it into your marital trust doesn't magically make it from yours alone into a marital asset. And then let's talk about Prop 19 horrors. For those of you who are really already invested in real estate, and this is true even if you just have your primary residence, but you have more than one child. The old rule, leave your real estate empire to as many people as you like, many children as you like. And they inherit it and they're so happy because they can sell it and usually no capital gains, or they can keep it and they don't get reassessed, right? They keep your really nice low property tax value. The party is over. It's over. Why? Because the people of California voted for this. It's very terrible. And if you are not happy with what I'm about to tell you, I want you to call your local politician and start screaming at them to get this fixed. The new rule is that you leave your real estate empire in California to your children, property is going to get reassessed. There are very limited carve-outs, very limited carve-outs. Why does this matter? Even if you don't care about what happens to your own real estate, your commercial corridor is going to be destroyed. Think about all the businesses there. When the owner dies and that property gets reassessed because it's commercial property and no one's living in it, how are the new owners going to be able to afford the property taxes? They're going to have to raise the rents. How does a bakery afford that increase in rent? They can't. They can't. Your neighborhood's going to be destroyed. If you think about your kid, like the kids buying each other out, we've got Prop 13 reassessment, transfer tax, income tax. It is a financial bloodbath. You cannot think my kids will buy each other out of this piece of property. It's a mess. The family will lose the property. So that's my screen share. That's kind of the overview as to why you absolutely have to put your assets in the trust. And you really do need a lawyer to help you do all these things. I see deeds all the time that make absolutely no sense. I spoke to a woman really recently who told me that she owned real estate. It was her husband, and her brother each owned a third. So we pulled the deed. No, her brother owns half of that property, and she and her husband own half of that property. It's community property, right as survivorship. They bought it 11 years ago. They did this on their own. So now if they try to fix that, it is a mess. There's no good way to fix it anymore because of Prop 19. It's going to trigger all kinds of tax problems. They're with a real estate lawyer now and a Prop 13 lawyer now, trying to figure out some creative way out of this huge problem. If you take title incorrectly, you are really shooting yourself in the foot. You're creating problems for yourself.
Mm-hmm. How do you avoid probate?
You avoid probate by creating a revocable trust.
Mm. Okay.
That's how you do it. Sometimes, yeah, that's really how you do it.
Okay. And, you know, the audience, do you have questions? Dave or Lucy, do you have any questions?
Yeah, I have a question. Well, first of all, thanks. This is really informative, way over my head. So it's really good for me here.
Oh no, what part went over your head? No, let's clarify.
Oh, no. I understand what you're saying. The whole subject's over my head. So it's good to hear about. I just wanted to ask, when you were talking about, I guess it's called probate. If you have a house and you die and there are no instructions, there's no trust, who paid the property tax? And I think you gave a 3-year example. Who's responsible for that property tax during that time?
The estate. So the dead person's stuff. But here's the problem. What if when you die with the house and really not much else? So there's no liquidity. Or you die and all of your bank accounts have a transfer on death beneficiary, right? So you had $400,000 in a bank account, but Lisa is the beneficiary. So that money's not in your estate anymore. It went to Lisa. So now who's paying the lawyers? Who's paying the property tax? Who's paying the insurance? Where is this money coming from? So anytime you're leaving real estate in your estate, you have to make sure that there is some cash. Also, because there's all this work that needs to be done, even with a trust, we need liquidity. You can't have all your money tied up in real estate, because then no one can function because, you know, anytime someone dies, we got to marshal the assets, do a tax return, pay the final debts. There needs to pay a lawyer. There needs to be some liquidity.
And
I was gonna say, and if there's no will or there's no instructions, who's gonna take care of all that?
Yeah, it's a
Yeah, who
really
does
good
take care of
question.
Yeah.
Yeah. Probably someone who wants to get their hands on some money. Somebody who wants to get paid that executor fee finally when the house is sold.
Okay.
Yeah.
And when the house sold, would the proceeds have to pay off back debts like that? If
Of
they had?
course.
Okay.
Of course. Yes. Yeah. Having a revocable trust that designates where your stuff goes does not get you out of owing people money. And dying with no plan absolutely does not get you out of owing everybody money. And I want to make a really important point is that if you die without a revocable trust, everyone will know. Everyone who's interested will know, including everyone on the dark web will know how much you were worth when you died, who you owed money to, and who's getting the inheritance, because that inheritance comes in just cash, right? Or houses. So who comes around those people? Creeps, weirdos, predators, grifters, bad people. So it's only by having a revocable trust that you can avoid this probate problem, and that you can really protect the people that you love, that you want to leave assets to, protect their privacy so that nobody knows when they're getting or what they're getting.
So Patricia, the trust is actually going to say, you could write a trust to say, okay, upon my death, this is my beneficiary, and this bank account's going to take care of all the expenses, and this person gets the house and whatever to do with as they want.
Right. So when you
Yeah.
use a revocable trust, when you use a will, all you can really say is so-and-so gets this and so-and-so gets that. And that's all you can do. And that's the end of the story. If you use a revocable trust, you can say, listen, I want my stuff to go to, I want the house to go to Muriel. And, but if Muriel's dead, then it should go to Jane. And you can also say, you know, the cash in my estate, all the money that I've funneled into this trust, that's going to be used for the administrative costs. It's going to be used to pay the trustee. And then also certain people are going to get a certain amount. So it's a much more elegant and I think efficient way to deal with an estate. And if you have minors, you know, this trust may be in place for a really long time. We're waiting for them to grow up. Maybe you're leaving your stuff to people who can't manage their own affairs. They're just not qualified, or you don't like who they're married to. You don't trust that person. So it protects them. It protects your legacy, your money from getting into the whoever you think the wrong hands might be.
Mm-hmm.
So, and my last question, when you have a trust, how do you update it? And does that cost money? Are there fees
I
for
love
that?
this. So a good estate planning attorney should call you back every 3 years. You might think everything's fine. I have all the same stuff. It's all the same people. Nothing has changed. The problem is that the laws change. One of the biggest changes in the last 3 years was Prop 19, right? So all of my clients who, well, we're going to leave the house in the city to our son, but the vacation cabin in Tahoe to our daughter, these aren't apples and apples gifts anymore. These are apples and oranges gifts because of the tax consequence with property tax. And so I think it's really important to see your lawyer every 3 years. I would say that most of my clients hold steady. There's not a lot to be done, but I just want to check in and make sure everything's okay. But every once in a while, we do have to dig in and change the documents. And the cost on that is, it depends. How much work am I doing? And so we just figure out at that time a flat rate for that work.
Thank you.
Yeah, but estate planning is not a one and done. You can't say, oh yeah, I did my estate plan 20 years ago. Boy, is that not going to work properly. That's going to leave a mess. And it's really going to leave a mess for a surviving spouse. The surviving spouse is going to feel that the hardest. And because there are probably a bunch of weird tax traps in there. But it also is very likely that if you haven't done your estate plan for a long time, that all your assets are not properly flowing through that trust. that your beneficiary designations aren't done because you've just forgotten that you even had a trust. None of your bank accounts are set up properly. It'd be really common. It'd be really unusual for me to see a 20-year-old trust that actually had all this stuff in it. I've never seen one. I see them and they're all empty, including the house isn't in there because some lender took it out for a refi and never put it back in. So usually I see empty trusts. And if your estate planning lawyer isn't calling you back all the time, that's a worry, because then when the worst thing happens, who do you call? You should know exactly who to call. You're calling your estate planning lawyer. And whether or not she or he does this post-death work, they can walk you into the room to get it done, or they're a known quantity to you. They can help with this.
Lucy, do you have any questions?
Well, actually, that was a good question about updating your trust that I wanted to ask about. We do have a trust set up. It's maybe about 6 or 7 years old now. And the people who set it up moved away from Glen Park.
Oh.
And yeah, and now I hear that they've even moved into different areas, and we didn't really want to go with them. But my question is that in the meantime, there's not much change in our estate, except that we did sell our house and bought. We've moved into the East Bay. And does that mean? I guess it means we have to update the plan, since the house.
This is a great question. So your documents, a revocable trust generally assumes that you're going to get a different house, you're going to have different banks, that all of your assets are going to change over time, right? So you're not trapped with those assets. It is really, really important, though, that over time you make sure that this new piece of property that you bought has that been transferred to your trust.
Mm-hmm.
Right? So that's really key. You know, you're saying that your lawyers moved away. If they're still in California, they can still be your lawyers.
Yeah.
Geography doesn't matter anymore. Only the lawyers who drafted the trust, if you have a small amendment, a small change, they can make that small change for you and not charge you very much. Any other attorney that you go to is not going to be able to do that. And the reason for that is once we touch, the last one to touch the document is on the hot seat if there's a problem with those documents.
Mm-hmm.
I am not going to expose myself to malpractice for something someone else wrote. So like if you came to me, we would have to restate and redo all of your documents, because I'm not going to have my name associated in any way with someone else's documents. And you would have to pay me so much money to go through all those documents to tell you what was okay and what wasn't and what I would change. I'd rather just run all new documents. It's cheaper and less aggravating for me. Actually, I won't do it because I find it boring. I just don't do that work. I don't like it.
Oh,
Yeah, so I would, you know, call your old lawyers and tell them that you bought a new piece of property and tell them that you want to come in for a review.
Mm-hmm. Mm-hmm.
Or
Yeah.
call me and we'll just do the whole thing from scratch.
That's right.
And let's talk about old trusts because the philosophy around leaving people money has changed. So the old way to do it used to be, oh, for the kids, they can have their money when they're 25, 30, and 35. Boom. The trustee shall distribute and the money goes out. That is old thinking. A lot of successful people in COVID now have creditor problems. Major medical, bankruptcies because they lost their businesses. The last thing they need as a 35-year-old adult is losing a parent and all of a sudden here's cash because they owe other people cash and they're not going to get to keep it. Another problem with this is so many people now get RSUs. And so money held in a trust over time, there's a lot of tax there. And when it comes out of the trust, it's just a tax bomb. So if you've ever gotten RSUs or been through an IPO event, that's a tax bomb. So here we are potentially really smacking somebody down with tax and giving a disproportionate amount of money to the IRS because the trust is requiring that this money be pushed out. The new way of thinking is to allow the beneficiary to pull money out on their own time. And we put controls on it. We do intervals. You know, you have to be at least X years old and you can take out up to a certain percentage. But in the interim, when and let's say, you know, for the first time, you take out 15%, and the next time you're taking about a little bit more. The next time you can take out a little bit more. But between those triggers where you're allowed to withdraw cash, you can also come and ask, hey, can I have help to buy a house? Can I have help to pay for my education? Can I have help to travel to Guatemala to see my grandmother? Can I have help, please, money from the trust? But we're just not going to let somebody get cash. That puts your beneficiary in the driver's seat. It lets them make really smart decisions. It lets them get their own team together to figure out what's tax smart, what's asset protection smart, what am I doing with this money? So I would, Lucy, look in your trust and see, how are you leaving assets to people? Even now, if my clients want to leave, $200,000 to their best friend and she's 60 years old, I don't give it to her in cash because we don't know what kind of credit or problem she might have. Her credit card might be out of control because of what happened during COVID. And so I'd rather leave it to her in a little, instead of it saying outright distribution to Francine, it would say, 1 year after this $200,000 little mini trust is funded, Francine has the right to withdraw all of it. And that gives Francine a year to wrap her head around what she's going to do with this money. But if the minute she pulled that money out, someone's going to take it from her, she could just leave it in there and use it and direct how it could be used for her. So there's really been a sea change in the way that estate planning lawyers think about people getting money. We are, of course, focused on what do you want to do? And then we have to flip it and say, what does that feel like for the person who's inheriting? How can we protect the person who's inheriting? So that may be a real change in your documents, Lucy. And it doesn't mean that the old way was wrong. It's just everything has changed since you did your documents. The whole world experienced an upheaval, and a lot of people lost a lot of money. And also with the continued, I don't even know how I want to say it, like all these people who work in tech, and they make so much money in so many weird ways. That has really shown us over and over again, this is not a blip. There is not going to be a dot-com bomb. This is a new way that people are getting paid. And so we really have to take into account IPOs and RSUs, because it used to be rare. And now it's like every other week in San Francisco, somebody's having one of these big liquidity events.
Thank you.
I just, on a different topic about insurance and trusts, I always like to make a point is, if you're holding your house in a trust, the deed in a trust, then you should loop your insurance agent in and mention to them that the deed reads your trust, not your name. Because if they're insuring you, does that mean, are they also insuring your trust?
So you always, at my firm, we always provide the insurance agent with a copy of a certification of trust. It's just a couple pages saying, under penalty of perjury, I have a trust, here's the date, here's the name, I'm the grantor and trustee. What you want your insurance agent to do is name your trust as an additional insured. So you're still being insured, you as a person, that's important. And then we name the trust as an additional insured on those policies. And that way, I don't think the insurance companies can win the argument of, oh, they transfer it to a trust, so it's no longer insured. But it just gets us over that nonsense, stupid argument, and it makes it very, very clear.
Yeah, it just protects everyone, definitely. Anybody have any other questions? Patricia, anything else you want to add to this? Oh, no. Dave, do you have another question?
No, I don't. Thanks.
Okay.
Thank you so much for nerding out with me and talking about all the rules related to real estate. The takeaway is everybody 18 and over needs an estate plan. Everybody. Anybody who owns real estate has to have a revocable trust. If you have real estate, you have to make sure you have a revocable trust and really good insurance, have umbrella insurance. If you don't know what that is, call your broker. If you're DIYing your insurance, call Judy and let her get you with a really good agent, because it's not okay. And the rules of the game have changed with Prop 19. It's really important for anybody who owns real estate who has multiple children. It's really important for anybody who owns more than one piece of real estate. Get back with your estate planning lawyer and have a really thorough discussion as to what's really going to happen now when I die, because it is a sea change. Getting reassessed is every Californian's nightmare.
Yeah.
And so my name is Patricia Fonte, and my law firm is Fonte Law, and we really do practice estate planning with heart. We give a very high level of service to every single client, and we work with middle-class people. Estate planning is about who you love, who you trust, and who is counting on you. It's not about how many dollars you have. Everybody needs to have an estate plan. Thanks for
Great.
having me, Judy.
Well, thank you, Patricia. I appreciate it. And on that note, with no other questions, we'll say have a good rest of your day and thank you for attending.
Thank you so much.
Okay,
It's really helpful.
bye. Bye.